most of the time when I see a home equity line of credit come in, there's a stamp on there or there's an allonge, and they've just sort of said, okay, pay to the order of so-and-so. It doesn't work in a lot of cases. Now, sometimes you just put your proof on in your pleading. Foreclosure case, here's our home equity line of credit, here's our mortgage. We say this amount is due. We've attached all the documents. It might include allonges. If nobody asks, if the borrower doesn't raise a defense based on that, the judge is likely going to go ahead and grant you judgment. But, the minute you say that, the minute you feel comfortable about that, you're going to have a clever borrower's attorney come up, and he's going to have done his homework, and he's going to try to knock you down. So you may have to do some other pleading in that complaint, like I mentioned earlier, like a declaratory judgment action to say, hey, look, I got this home equity line. I should be deemed the right person to enforce it. Judge, in addition to my foreclosure counts, give me declaratory judgment that I'm the right person to enforce this. So there are ways around it, but that's something that a lot of people, it's a pitfall. You think you've got everything lined out. You're feeling really good. You got allonges from the first person through all 5 assignees. And then you might not realize that those might not be as effective to transfer that home equity line to you as you thought.
Is that something that could come up? Like the HECM loans that I've bought, the home equity conversion mortgages, I've only ever bought non-performing, and the reason they went non-performing was because the borrowers passed away.
Right.
So I haven't had that argument, and I hadn't ever thought of that, but I see where you're going.
Right. So it's an interesting question. It's really not come up in our firm that we've had a collateral issue with HECMs. HECMs are reverse mortgages. The interesting thing about them is that every HECM loan has 2 mortgages. Mortgages, because HUD comes back in and they secure and have a mortgage the property in the event that the first mortgage, the lender has to make a claim against HUD for reimbursement. So there's that. Most of the time, though, it's a good question because it is sort of a home equity loan.
Yes.
I do think that it's going to be hard to get a state court to say that the way HUD or the original lender acting under the federal statute has assigned their notes and mortgages to the next person is going to be ineffective under state law. I think I could make the argument that the federal law trumps the state law. It doesn't mean to be sloppy with your HECMs, but at the same time, I think there are some more protections built into the HECM circumstance than with standard home equity lines of credit.
Interesting.
All right.
So what other scenarios do you see that we have to be kind of watching out for, or you've seen used in the courtroom that had standing, and either you were able to be a savvy attorney to get around it, or you took note of it and said, oof, I got to make sure I watch out for that?
Payment histories, if you're in your collateral review process and you have a payment history, that's very helpful. If you don't have a payment history, but you do have a good chain of service or transfer letters, then that can give me a little bit of ammunition if the issue comes up. A lot of times we'll see when a borrower does get an attorney, what they'll say is, hey, look, yeah, he's in default, but you can't prove how much he owes because you don't have a full payment history. It's funny what the assumptions are on the other side of the bar. So, we know that, well, a payment history is what it is. And if there's no payments, there's nothing to put in the history. And if it's been in default since, 2016 and it's changed servicers a bunch, then each servicer has been nothing for them to record. And they record a 0, but a lot of times, especially sort of the mid-level in size servicers and below, there's nothing to really record there. They just But you have now 3 servicers that have gone by in your chain since somebody had kept a payment history. And it might have been so long ago. I mean, if this note mortgage was originated in 2005, they might have paid for the first 5 years and then it got transferred 15 times. And then you're trying to figure out the pay history. Well, so that's why a pay history is great to have. If you don't have it, we can at least subpoena the prior servicers and say, provide us your pay history. We're way down the road and we're trying to foreclose on this mortgage. But the opposing counsel for the borrower will sometimes try to make it seem like you're defrauding the court because you don't have a pay history, when their client is sitting right there across from you and they know they haven't paid anything in 10 years. So there are ways to get around that. nobody likes to spend the money on deposing somebody, but I've had to do that before. I tell a story that one time we were getting really kicked around on a pay history issue. And in a lot of states, there's the judges handle criminal law, they handle business law cases, and this might be one of 10 types of cases. So they're not really well versed on foreclosure law. So the judge in that case was really giving some credence to this. Well, the plaintiff doesn't have the pay history argument. Well, I deposed him, and then I showed him in the course of the deposition his own bankruptcy petition that he filed, where he listed the second mortgage. And he said exactly how much was due on the second mortgage in his own bankruptcy petition. And very soon thereafter, after he admitted what was due, I had solved my payment history problem because I didn't have to. I got an admission that here's the amount that was due then.
Yeah.
And then was about 5 years ago at that point. Then I just had to do math. What's the note rate, late fees, all that kind of stuff. And then I could go to the court. We ended up settling that after that deposition, which was pretty.
I know that a lot of times we get notes, you don't get the full pay history. Nathan, I don't know if you have the same experience where you may get the last 3 years. You don't get the last 25 years of payment. And in the beginning, that kind of concerned me, but it was like, listen, you saw where it was when you first got 3 years ago, and to today, it made mathematical sense where that's where it should be if it was. So I've never had a problem with that. I see Cindy had a question. Have you dealt with notes outside statute of limitations?
Yeah, I have. It is not a great place you want to be. And I'm glad you brought that up because we're working on sort of a 50-state survey of statute of limitations. David, I know you keep some records in your files on what statutes limited, but we're going to sort of roll it out in blog posts and talk a little bit about the nuances. But it's a great question. Statute of limitations, very difficult to get around.
So real quick, what is statute of limitations for those who may not know?
Yeah, good. I'm glad you slowed me down. So each state has a period set by a state statute after which you cannot enforce in a foreclosure action a mortgage, or after which you cannot seek payment on a note. It varies. It's all over the place, and it's always changing. Since I've been practicing, since I've been doing foreclosure work in Ohio, so 2012, the statute of limitations has come down 3 times.
Wow.
Or yes, it's come down 2 times. It started at, I think, 10, and then it went to 8. Now it's at 6. So 6 years from what's called the accrual date. Now, here's the big misconception. It's not always, in fact, in my states, it rarely is the date of default. It's not the date on which they started paying. So if you have a situation where you're looking at a collateral file and you've got a demand letter from a prior servicer that's dated 2010.
Yep.
And it says, hey, you haven't paid since so-and-so, and that's what the payment history indicates. It could mean that you're time barred, could mean that you can't move forward with foreclosure on that. Here's what it doesn't mean. It doesn't always mean that the lien goes away. If the borrower dies or wants to sell the property, they may still have to clear out your lien.
Sure.
So that's the first thing to think about. The second thing is the default date is not necessarily the date on which the statute of limitations starts. That accrual date is usually the date on which the loan is accelerated. If you dig into your mortgage and your note, you'll see some language in there that says, if you are in default, the lender shall send you a notice that you are in default and that you have no less than 30 days to cure your default, or the lender may accelerate the amounts due. When that happens, then you basically said, okay, this is due. And that is your accrual date for the statute of limitations in all my states, in most states I know about. So those are the considerations. Can you get around that? It's not.
And there's different states have different parameters with, I have my list here I'm looking at real quick. Is that the last payment received, maturity date, due date, acceleration, start of foreclosure, origination, under seal, judgment. And we always look at the fact that the ability to advance the due date and also the non-merger and due deed in lieu.
I'm glad you mentioned the maturity date too, because the maturity date is the sort of the adjunct to the acceleration date. So if somebody goes in default and you have, let's say it matured that next year and you didn't send a standard demand letter until several years later, Well, there's really nothing to accelerate on maturity. Maturity is an acceleration of any unpaid amounts. So you would want to look at the earlier of maturity or acceleration.
That makes sense.
Yeah.
Yeah, awesome.
It can be a tough one for sure.
Yes,
and as far as like advice, talk to the attorney, because every state's just a little bit different. They're going to handle a little bit differently.
Yeah, I'm glad you said that, because everything I say today is educational purposes only. I'm not giving legal advice.
Yeah.
I should have done that at the outset.
And some states allow you to do certain things that other states don't. It is state specific. So just keep an eye on that. And laws are changing all the time, right? We've used the ability to advance due dates in Florida and stuff like that, where some states don't allow you to do that to avoid the statute of limitations. Again, speak to your attorney, make sure if you're buying notes that have a long due date that you're making sure. And if you're if you believe you're outside the statute of limitations, ask your seller what they've done to avoid it, right? Hey, they may have said, listen, yes, we sent a demand letter and we started this and this happened, which may kick the can down the curb with statute of limitations to avoid it.
One point on that real quick, because if somebody is looking at a demand letter in their collateral file and it says, and it's dated 2010, and you think, okay, well, if they sent this on January 1st, 2010, then 30 days after that, I'm started the statute of limitations period, I must be time barred. That's not necessarily the case, because look very closely at the language of that demand letter. If it says, if you don't pay within 30 days, we may accelerate the amounts due, it's a very different meaning than we shall accelerate. So if it says shall, you're probably more in danger of being time barred. If it says may, then really what you've done here is you've sort of shifted the burden on the defendant to show that somebody along that line, some servicer, actually did take some sort of internal accounting efforts or other evidence of acceleration that they can bring to bear. Now, it's not a get out of jail free card, the may versus the shall, but it is something to look at closely and maybe not give up on a collateral file just because you think you're sunk on the statute of limitations.
Cool. Well, I know we're getting to our witching hour of an hour, so we're gonna let Nathan kind of ask. We kind of hit on it before, but Nathan, what's your final question?
And I appreciate the discussion, because this is like, it's a big deal. We're buying this collateral file, so we better understand it, know how it works, and then know what some of the potential pitfalls are. So that's really good.
And why the owner finance and seller finance people need to understand why their paper has to be in line. Because when we have to, or may have to, foreclose on it, if it's not in order, we can't foreclose, and you basically have a junk piece of paper.
Collectability, all those things. I mean, it makes such a difference. So we want to make sure it's done properly up front. That just saves us time and energy and money, and Dan doesn't get paid. So, and
we've seen all kinds of stuff out there with collateral being so bad, where start dates weren't on the actual note, right? Where the PITI was fixed. We've seen like missing payment amount, like all kinds of stuff has been seen on the seller finance world that just is dangerous. And they don't see it because, hey, they're paying, who cares? So
yeah, it matters.
Yeah.
So we kind of talked about this a little bit, but you talked about seeing a wave coming, maybe not the tidal wave, but maybe more just like the tide coming in. What's kind of your prediction? What do you see coming up?
So it's hard to get attorneys to make predictions, right?
It depends, right?
Yeah, it all depends. So, I think probably, if I had to guess, the defaults are going to sort of ramp up. I think there are people who, we've already talked about it, they're needing to borrow money to meet their basic needs. Right now, I think it's like 11% more expensive to live than it was 4 years ago. Yeah. And salaries have stayed relatively flat. So that's going to catch up. I do think, though, that from just a general real estate market perspective, there's going to be some opportunities probably in this seller financing world. You're going to have a lot of younger people entering into the home buying market. I say younger. They might be time home buyers, but they've been locked out because of interest rates and down payments. So if I was looking to place a bet, I think that the sort of the unique seller financing models will probably create some opportunities for them to buy, but also will eventually result in a wave of foreclosures. Don't sleep on the reverse mortgages. I think the reverse mortgages are going to be big for probably the next 10 years or so.
Yeah.
Baby boomers, right now, what they're not doing is they're not borrowing the $40,000 on the loan that comes in the mail. I think they're going to start getting very comfortable with reverse mortgages. And if you get them, they're very, I mean, sometimes they carry a high price, right? But
Of course.
if you can get them, the foreclosure process is made relatively easy by the fact that you don't have any threatening borrowers on the other end.
Yeah.
I don't mean to be coarse, but if we're talking economics, it seems like it makes economic sense there. So
Yeah.
I don't know. I kind of danced around it. But I would love to get busier.
Yeah.
Usually, what happens though is when the market is bad for everybody else, we're really busy. So, and I guess also last thing, don't discount the fact that some of these student loan borrowers are not getting the forgiveness that they had hoped to get.
True.
And, they might have been sort of on, stringing this along bit by bit. But if they end up, not paying their mortgage 1 month to pay a student loan bill, or they go into bankruptcy, the post-bankruptcy foreclosure options will be there too. So,
Yeah, absolutely.
Yeah.
Well,
That'll
Dan,
be interesting.
we appreciate your time. If guys, we'll have the link for get his information in the chat. If you had any questions for Dan, please reach out to him. He's really easy to talk to, very friendly. He was a DME last year. I'm sure he'll be there this year, next year. But he have a booth. So Dan, I appreciate your time. Hang on for after hours, but it was awesome information and really broke it down for a point that everyone can understand the importance of the collateral review being one of the crucial points in due diligence.
Yeah.
Thank you so much.
Yep. Thrilled to help.
Awesome. Thanks, Dan.